The country's highest court is today hearing a challenge by independent candidates. They're challenging the decision not to allow them to stand for positions in the National Assembly or provincial legislatures if they're not part of existing political parties. For more on this, we're joined by ENCA's Moloto, who's live at the Constitutional Court that's here in Braamfontein. Moloko, good morning to you. The first question I want to ask of you is a point of clarity, really. Is the ConCourt hearing the merits of this case now, or merely considering whether this question should be answered before the 8th of May?
Well, Oli, in April this year, the Western Cape High Court made a ruling essentially dismissing an urgent application by this group of appellants who had wanted that Western Cape High Court to set aside or to declare the Electoral Act, the provision that relates to the eligibility of people to contest for the provincial and the national elections invalid. But of course the High Court dismissed that particular application. So what happened was that the appellants, who are led by the New Nation movement, then decided to approach the Constitutional Court directly. So what they are doing and what is going to be happening today is that the Constitutional Court will be hearing an urgent application for leave to appeal that decision or judgment of the Western Cape High Court. So the Constitutional Court will decide whether that particular matter must be heard as the appellants are bringing it forward. So a decision will then be taken, and we're not sure whether if the court agrees that they will hear this matter on the urgent basis, whether they will be able to hear the matter today or they will set a new date. Remember that at issue here is the fact that the current Electoral Act of 1998 provides that people who want to be members of parliament and members of the provincial legislatures can only do so if they are members of political parties. So the applicants are saying that is wrong. Actually, they must be allowed to contest as independent candidates the same way they are allowed at the local government level. Remember that people can contest for wards as independent candidates. So they are saying the Electoral Act actually is against the Section 19 of the Constitution, which essentially says that South Africans can stand for public office, and if elected, they must hold public office. And remember, Oli, that if you read Schedule 6 of the Constitution together with Annexure A, it indicates that actually the 1999 general elections were a deadline for the current electoral system that's being used now, where political parties can forward those candidates. Ideally, the 2004 elections going forward should have been held under a new electoral system. And we saw in 2002 the cabinet under former President Thabo Mbeki appointing an electoral task team that was chaired by Frederick van Zyl Slabbert, who recommended that there were several recommendations. Among those was that independent candidates should be allowed at some point. Of course, there were different proposals and suggestions by members of that electoral task team. Then fast forward 2017, we saw former President Kgalema Motlanthe, who had been appointed to review some of the legislations or make suggestions. And when he submitted that high panel report to Parliament, he was blunt. He said that actually independent candidates must be allowed to contest both at the provincial and the national assembly, the elections. So the ball really is on the court of the Parliament. Interestingly, today, Oli, the President is respondent number one in this case, And the president, together with the Speaker of Parliament, are not opposing this application by this group of appellants. Only the Minister of Home Affairs, as well as the Independent Electoral Commission, are opposing this application. What is interesting is whether the fact that the president is not opposing it, whether he kind of like agrees with the applicant's arguments, or whether he will align himself with the arguments that will be posited by the Minister of Home Affairs, since the minister reports to the president. But one of the arguments that is posed by people who are saying independent candidates must actually be allowed to contest independent of political parties is that they say currently you have a situation wherein government is constituted at the will of party political bosses, because the MPs who go to parliament and the MPLs are selected by political parties. They are not voted for by the electorate. So they were saying that actually as a result, when it comes to voting in parliament or the legislatures, they are unable to vote on their conscience. Instead, they will always toe the party line.
Moloko Moloto, live for us at the Constitutional Court. Thank you very much for that comprehensive explanation.